Good morning, everyone. Welcome to our 19th year of presenting workshops for mental health professionals. We really enjoy doing this, and I hope you do too, and that you get benefit from every session that we have. I hope everyone is safe, that your homes are intact, and that you have electric. So today, I hope to give you a global as well as inside look at pre- and postnuptial agreements, especially now that spouses have been living in close quarters for the past 5 months and perhaps having amped up disagreements over finances. Postnuptial agreements may help them resolve their issues. Similarly, where fiancés may be living together and have disputes over financial matters, a prenuptial agreement may help them resolve their issues going forward and when they get married. So a somewhat common situation we see is as follows. Parties are engaged and planning to marry in a year. The groom is in a family business. All along, his family is insisting that he have a prenuptial agreement prepared. So the family has their business lawyer recommend a matrimonial lawyer to prepare a prenuptial agreement. After many redrafts and 1 month before the wedding, the draft is finally given to the bride-to-be to review with her lawyer. And the agreement provides that upon a divorce, the husband's interest in the family business, even if he works there full-time during the marriage, and even if the bride works there, remains his separate property. Any other businesses he invests in, a separate property. And also the income from those businesses remains a separate property. There are no provisions for maintenance, or what used to be known as alimony, even if there are children born of the marriage, and the wife remains at home to care for them. And there is also an estate waiver, meaning if the husband dies, the wife has no claim to his estate. The wife's attorney looks at the agreement and advises her that there are major terms which must be inserted and must be negotiated. It takes 2 weeks for her attorney to provide a counterproposal, which involves the wife's entitlement to a payout concerning the assets of the marriage and for maintenance, which would increase every year as the parties are married. So now, during the last 2 weeks leading up to the marriage, the parties are preoccupied with arguing over the terms of the agreement rather than basking in the glory and joy of their wedding arrangements. On the morning of their wedding, they are meeting with their lawyers to sign the agreement, with the groom telling the bride she either signs or there's no marriage. So the bride signs under pressure, knowing that there are several hundred guests expected that evening. But has the husband done himself any favors by delaying the preparation of the agreement and by not providing adequate terms for the wife? Just this morning, I saw that on the news, there was a title, Nicole Young seeks to challenge prenup in Dre divorce. Now, Dr. Dre is a rapper and quite wealthy. Nicole Young says that Dr. Dre tore up multiple copies of their prenuptial agreement, and they both agreed it was no longer valid. Nicole Young is challenging the validity of her prenuptial agreement with Dr. Dre, claiming that the rapper tore up the agreement a few years into their marriage, thus rendering it null and void. In filing this week, Nicole is asking the court for an early trial in order to determine whether their prenuptial agreement is valid, as the enforceability of that agreement will affect the scope of the remaining issues in the case. Nicole said in the filing that her husband's net worth is estimated to be in the ballpark of $1 billion, and that he earned the majority of that wealth during their marriage. In his response to Nicole's divorce filing, Dr. Dre said that the couple had a prenuptial agreement. But Nicole is now saying that she felt pressured to sign it, and that later on in the marriage, Dr. Dre agreed that it was no longer valid. Before our wedding date, Andre demanded that I sign a premarital agreement that 16 of his lawyers had drafted, Nicole said in her declaration attached to the filing. Andre at the time was a well-known producer and rapper in the music industry, but had not reached anywhere near the pinnacle of his music, entertainment, and business career that he achieved during the marriage, she said. He told me that I must sign a premarital agreement or he would not marry me. I was extremely reluctant, resistant, and afraid to sign the agreement, and felt backed into a corner, Nicole said, adding that she was left with no option but to unwillingly sign the prenuptial agreement shortly before their wedding because of the extraordinary pressure and intimidation by Andre. About 2 to 3 years into our marriage, Andre acknowledged to me that he felt ashamed that he had pressured me into the signing of a premarital agreement, and he tore up multiple copies of the agreement in front of me. Since the day he tore up the agreements, we both understood that there was no premarital agreement and that it was null and void. And she added that she never even received a copy of the agreement. So the law allows parties to contract both before a marriage, which is a prenuptial agreement, and during a marriage as to how financial issues will be dealt with upon divorce or death of a party. In today's world, the use of prenuptial and postnuptial agreements has become quite popular. The prenuptial agreements are most prevalent, but there has been an upsurge in postnuptial agreements, which are generally used where the parties wish to remain married, but are having financial disputes causing difficulty between them. For example, I recently had a case where the husband was spending close to $60,000 monthly to send his daughter from a prior marriage to an exclusive rehab center. And the wife was becoming concerned about her retirement, that it would be affected by this. Otherwise, the marriage was stable. So they entered into a postnuptial agreement, splitting up their assets in a way that would not dilute her share of assets going forward. And once that was taken care of, the parties were okay in terms of their marriage. In most cases, the moneyed party will prepare the agreement for review by the less moneyed party to protect their property rights, both current and future. Where the parties are married and have neither a prenuptial agreement or a postnuptial agreement, and there is a divorce proceeding, the parties will resolve their issues where possible with a marital settlement agreement or a divorce agreement. Okay, this should do it. Okay, there we go. So in a marital settlement agreement, you're dealing with how to split up assets and debts which have been accumulated during the marriage, and to determine whether maintenance is payable to a party based on historical facts. So you see where the slide for divorce agreements shows you a fully baked pie, and it's that pie that the parties are looking to split up. Okay, and when you have a prenuptial agreement, you really need a crystal ball. And the reason for that is you don't really know what will occur during the marriage. So you really must think very carefully about what could happen and provide for many different variables. Most clients are quite surprised when they realize how important it is to think of all of this and to provide as many possibilities as you can think of. Will there be businesses? Will there be children? Will a party become disabled? How long will the parties have been married at that point? And so on. Now, with postnuptial agreements, you see, you have generally a mixture of historical information and speculative considerations. And the reason for that is that the parties generally have been married for some period of time and already have built up a history in their marriage. But also, they want to continue to be married. So you have to look forward as to what could happen in the future as well. Now, in order for any of these agreements to be upheld, they must be fair and reasonable when they're made and not unconscionable in their result. While parties can agree to what may be called a bad bargain, the results must be within some sense of reason. Otherwise, a court may very well set them aside. And the courts tend to scrutinize these agreements more so than ordinary contracts due to the fiduciary relationship between the husband and wife. The agreements are meant to serve as a roadmap, if you will, as to how things will take place. You can be very creative in establishing this roadmap. Generally speaking, where there are the agreements, where both parties are represented by counsel and the agreement is properly executed and the results are not unconscionable, the agreements will be upheld. Now, there are situations where a party refuses to be represented by counsel, and in those situations, it's very important that that party sign off both in the body of the agreement and a separate letter that they have been advised to seek representation. And despite that advice, they are waiving that right. Now, also, transparency as to assets and income is critical in these agreements. Each party must provide a financial statement describing in reasonable detail their assets and income, and where they can't determine the actual value, approximate values would suffice. A lack of transparency will raise serious issues as to the efficacy of the agreement. Now, where you cannot approximate a value to an asset, at the very least, you should set forth the asset and have the other party sign off on that. For example, if a party makes an investment in a biotech company trying to produce a vaccine, it may have little value now and no value later, or it may have huge value later. It may become the biggest asset in the marriage. These things must be set forth and understood. Other issues could involve whether a party has been deceitful or not inducing the other party to sign the agreement. So there was a case by the name of Petrakis, which was an action to set aside a prenuptial agreement between the parties. The wife had initially refused to sign, but 4 days before the wedding, she signed under pressure. That was her position. A number of factors were considered by the court in whether to set aside the agreement, including the following. The husband told her if she didn't sign the agreement, they wouldn't get married at the last minute. The husband told the wife he would not marry her unless she was Greek Orthodox and raised the children in that tradition. She thereafter studied to do this and learned to speak the Greek language. Her family had already spent $40,000 toward the wedding and expected many guests at the wedding. He also told the wife anything they acquired after the marriage would be theirs, and after they had children, he would tear up the agreement. And as stated above, the agreement was signed only 4 days before the wedding, which put a great deal of pressure on the wife to sign. The lower court took a holistic viewpoint on all that occurred and found that the husband really had no intention of ever tearing up the agreement, and that he fraudulently induced the wife to sign the agreement. And the court set aside the agreement, and the appellate court affirmed that lower court decision, setting the agreement aside. In another case, by the name of Petraka, the parties were married in December of 1995. In March of 1996, they entered into a postnuptial agreement. And the agreement provided that a jointly owned marital residence purchased for $3.1 million after the marriage and renovated for over $3 million was thereafter the husband's separate property, and the wife had no interest in that property. Also, the wife, who was a homemaker, waived her interest in the husband's businesses, including the appreciation of those businesses during the marriage. Further, the wife waived any claim to the husband's estate, including any right to an elective share, meaning that she couldn't claim, even if the husband cut her out of the will, she couldn't claim an elective share. At trial, the wife testified that the husband threatened if she didn't sign the agreement, they would not have any children and the marriage would be over. And the evidence had also showed that the wife had undervalued his net worth by nearly, the husband undervalued his net worth by nearly $11 million. And the appellate division affirmed the lower court decision which set aside the agreement, emphasizing that because of the fiduciary relationship between the spouses, the agreement would be closely scrutinized and that the terms of the agreement were wholly unfair. So there are two major areas which are involved with prenuptial and postnuptial agreements. One, what happens in the case of dissolution of a marriage. The other, what happens in the case of a death of a party. Without these agreements, the law provides that all property accumulated during the marriage is marital, and that a surviving spouse has a right of election against the other spouse's estate. Generally, that amounts to about 1/3 of the other party's estate. However, in these agreements, the parties can opt out of the law and make their own decisions on how things will take place. Now, many times I receive an agreement by opposing counsel representing the moneyed party, which provides nothing or almost nothing to the non-moneyed party. This is really the worst thing that the attorney and the other side can do, because the whole point here is to have an agreement a party can depend upon in the case of a divorce or a death, and that will not be set aside. It is very important, as I indicated before, to look to the future possibilities the parties may experience. You should consider the businesses the parties have and may become involved with, whether there's going to be a transfer of property or a change in the title to property during the marriage, whether marital funds will be contributed to separate property of the parties, whether a party will devote efforts working at the other party's business or contribute their separate property to the other's separate property, whether the parties will have a family and how that would affect one's ability to work and their needs, or what would happen in the case of a disability. Have the parties been married 3 years or 5 years or 10 or 15 or 20 or more? And will that have an effect on what the provisions should be? Will the agreement terminate at some point after a long-term marriage? Will retirement benefits accrued during the marriage be separate or marital? Is there a waiver of entitlement to specific property? And will there be an equivalent distribution of money to compensate for that? So would that depend on whether there are children? And so on. So these are all very important factors to be considered. Will life insurance take the place of a distribution of property? So you can see with these agreements that there can be many pitfalls, and it's very important to really try to cover them as best you can. Also, there are provisions you can make for special needs situations. I recently had a matter where a wife had a substantial progressive disability, and we used special needs and supplemental trust to enable that party to still get government benefits and then have the benefit of money from the other spouse. So the main goals of these agreements should be to protect assets in the case of divorce or death, and also to provide some reasonable degree of property distribution and support so that the agreement holds up when scrutinized by a court. So I do like to sleep at night, and when I prepare an agreement, I try to provide for all these things. I would never want a client coming in, knocking at my door, saying, "Jerry, why didn't you, provide for these things? Now my agreement's going to be set aside." So these are all very important things to consider. You see in the next slide, there are different provisions in an agreement. The consideration for the agreement and the validity of the agreement should be that the parties are going to be married together, and all the mutual promises that are made in the agreement are going to be upheld. In the preambles to the agreement, it should be important to describe when the agreement was first presented to the other party. And hopefully it was presented in enough time for there to be reasonable negotiation and not a last-minute situation. And the intention of the parties is to opt out of the law and what it normally applies, and to apply the terms of the agreement. Otherwise, there wouldn't be a need for an agreement of this nature. So normally, and if there's no agreement, the law will provide that everything accumulated during the marriage is marital. But when you opt out of the law, you can change that. Separate property of each party should be detailed and give a very full picture of what the other party has. And if there are going to be contributions to the separate property of the other party, let's say a party owns a home and the other party during the marriage contributes their own property or efforts to investments in that property for improvements and so on. What happens? Are they entitled to share in that, or aren't they? If there are liabilities that the parties bring into the marriage or develop during the marriage, that should also be provided for. And how the parties will cover finances during the marriage should be provided for as well. You don't have to be overly specific about that, because the parties will obviously have some discretion there. And then you would provide for what happens upon the dissolution of the marriage, what will be defined as marital property. And you can specifically define what marital property is. You want to make sure that you have some provision for marital property. And as I said before, where there are no provisions on these things, the agreement can be set aside. You can have provisions for how property will be disposed of and what the protocol will be for that. You can have an agreement for distribution of property, or as a substitute, a certain amount of money that would be distributed instead of the actual property itself. Also, there would be provisions in the agreement for maintenance, or as I said before, what used to be known as alimony. And you want to make, especially where there's a family, and especially where the wife, and it could be either way, wife or husband, but especially where the wife will most often be home with the children, what kind of provisions are going to be made, especially in light of the fact there's a family. Whether there'll be provisions for health insurance. Now, you can also make certain provisions for child support, although ultimately a court, if it doesn't adopt what you have in the agreement, can make their own decision on that. And then you want to make provisions for rights upon death, and what would happen with retirement benefits. Will retirement benefits be distributed between the parties, or will they remain to be separate assets of one of the parties? Okay, so there are a number of other more boilerplate provisions. You want to have a provision in the agreement generally for the non-moneyed spouse to be able to get legal fees from the other party. If after a certain amount of time there's going to be an automatic termination of the agreement, you want to have that stated very specifically. And as attached to the agreement, you would have a financial statement describing all of the property that the people come into the marriage with, or if it's a postnup, that they have during the marriage. And what's called an allocution affidavit, in which each party says they understand the terms of the agreement. They don't really have any other questions. They're in agreement with everything. And then they sign off on the agreement. So we'll take any questions now. If there are any questions, Sharon, do you see any?
Jerry, there are no questions. So if anybody does have any questions, you can type them in now in the chat, and I'll just check to see if anybody's got their hand raised. Otherwise, I guess it means you've answered everything.
Oh, okay. I doubt that, but okay. If anybody has any questions later on in the procedure.
Okay, wait, there is one question, Jerry.
Okay.
Do you need to have a lawyer involved to have a binding agreement?
Excuse me?
Do you need to have a lawyer involved to have a binding agreement?
No, but it's not a good idea for a party not to have representation. As far as the other party who has representation goes, they would want the one saying, I don't need a lawyer, signing off that they've been advised that they should have a lawyer. I would say have a provision in the agreement as well as a separate letter signing off on the waiver of that right to have counsel. But it can be binding if the agreement is done properly and there are those waivers and the agreement is signed, reasonable period before the wedding.
We got 32 participants. Hi, everyone. I am Derrick Rubin. I am a senior associate here at Wisselman, Harounian Associates. And I'm going to discuss today with you real estate, landlord-tenant law, some estate planning, guardianships, powers of attorney, wills, healthcare proxies, and living wills. I first apologize for not shaving since the storm occurred a few days ago. 4 trees fell on my property. One hit the house. Another took the power line down, the Verizon line down. I've got backyard littered with fallen trees, and thus no electricity, no internet, no nothing. Actually moved to the Hilton Garden Inn, and that's my new residence. But I hope all of you are well and hope everything is fine in your world. Okay, so since Jerry covered prenups and postnuptial agreements, I thought I would just continue on the discussion of a divorce. Let me just get my timer going here. Beautiful. Okay. Sometimes even before people want to get divorced, sometimes to avoid even a divorce, they try to get an annulment, which is though the marriage never occurred. Annulment can occur either with a void marriage or a voidable marriage. A void marriage would be such as marrying your sister or marrying someone who's already married. And a voidable marriage would be someone who is one of the following criteria, such as the person's incurably mentally ill for a period of 5 years or more, lacks mental capacity to enter into the marriage, is unable to consummate the marriage, or even fraud, such as a Orthodox Jew thought she was marrying a Jew and she really married a pro-Nazi member. All those items would allow you to get an annulment. Now, the heart of a divorce, if the case is not actually tried before the judge and the parties don't have a prenup or a postnup, then the heart of it is a stipulation of settlement. The stipulation could be anywhere from 5 pages to 80 pages, depending upon how complex it may be. In this stipulation settlement, it will cover, assuming there are children, 5 major issues. First, custody. Second, child support. Third, visitation. Fourth, maintenance. And the 5th, equal distribution. And I'll cover all those in detail. Now, you hear people come in and say, I have a simple divorce. Well, what would a simple divorce be? No kids, no assets, no liabilities, no real estate, no retirement accounts. The retirement accounts, people just want to go their separate ways. That would be a simple divorce. A complex, well, even if it's simple divorce, sometimes it's not so simple. I have a case right now where it's a 1-year arranged marriage, an Indian couple, and the wife left the husband, but she refuses to grant the divorce unless she is paid tens of thousands. Actually, I think the demand the other day was $100,000 from the attorney for a 1-year marriage, no assets, no kids, they don't own a home, and my guy makes $32,000 a year. But the attorney thinks that he can somehow drag $100,000 out of my client's father, who's very wealthy. So he can't get divorced until the parties agree. It looks like we actually have to go to trial on that. Probably be a 5-minute trial because there's no assets, no liabilities, no nothing. But that's a simple divorce, which is becoming complicated. Okay, let's cover a complex divorce. What's the first issue? Custody. Now, custody is actually broken down into legal custody and physical custody. Now, what do I mean by legal custody? I mean decision-making, deciding where your child goes to school, deciding what sports your child will be in, what summer camp your child will be in, what extracurricular activities, what religion the child shall be, what college the child should go to, and even medical decisions. If the child has some attention deficit problems, whether the child should be on Ritalin or some other medications or other treatments. Those are all legal decision-making. Now, when parties, I'll just cover this also. Physical custody is actually where the child lives. If the child's staying in mom's house more than 50% of the time, or it's staying in dad's house 50% of the time. Now, when parties are married, they have joint legal custody. They each have equal decision-making as to raising their children. Though, like in my case, I have a dominating wife, so I didn't have much to say, but the law said I have 50%, so I will go with that. Now, people fight all the time over custody, many times purely monetary, because some fathers realize if their child is with mom more than 50% of the time, they will be paying child support. So they many times will fight for custody just to avoid paying child support. Now, how does a court determine custody? Well, the governing doctrine for the judge and the court is what is in the best interest of the child or the children. The court, by utilizing that, the court will also, sometimes when a party requests custody, the court will order forensics. Forensics are a medical report used in a legal setting. And the report can be anywhere from 15 to 50 pages, cost about $5,000 to $10,000 to generate, and it'll be created by a psychologist, psychiatrist, or licensed social worker, which is either most of the times appointed by the court. Sometimes the parties can agree, but most of the times the court will just simply pick someone off their list. As I said, initially the report is that money amount. Then if the psychologist, psychiatrist, licensed social worker needs to actually testify, another $5,000. These are one of the hidden costs of a divorce. Now, at the end of the day, the report can come back, and I've seen reports after parties have spent $15,000 state, gee, dad and mom are really good people, they should have joint custody. Well, that's not what the parties paid for. That's not what they got. At the end of the day, who makes the ultimate decision on custody if the parties can't agree? It's the judge. Does the judge need forensics? No. Does the judge need input from the attorney for the child? No. The judge, because the judge has got a robe, that's the reason the judge can make the decision. So I tell parties all the time, if you can resolve it without the judge deciding it, that's what you should do. Okay, child support, the third component in a separation agreement. Under New York State law, we have something called the CSSA, Child Support Standards Act, which states that child support shall be paid until the child is 21 years of age. To simplify the formula, it's the gross income less FICA, which is Social Security, and Medicare taxes. Now, in 2020, the combined income cap for child support is up to $154,000. Based upon that number of both incomes, the court then will determine on a pro rata basis and how much money the parties are supposed to pay. If the, let's say, presumed mom has custody of the children, even though the formula states that she pays child support, she actually doesn't pay it, but will state forth what the husband will have to pay. This cap is adjusted every 2 years. Now, the court has discretion if the child support is above the $154,000 to award child support on that formula. First of all, let's cover the percentages. If there's one child, child support is 17% of that CSSA number I gave you. 2 children, 25%. 3 children, 29%. 4 children, 31%. And 5 children or more, 35%. So if the court goes above $154,000, they can still apply, let's say it's one child, 17% to the number above $154,000. It's my rule of thumb that a court will normally use $350,000 as a cap for high net worth cases to figure out what child support should be. So if a father is making $2 million, he'll only be paying child support on a cap of $350,000. Now there's statutory add-ons to child support: health insurance, unreimbursed medical and dental, daycare if the other spouse is working or trying to find a job or for education, and then discretionary for college. Now, what are our problems with, let me just check there we go. Just want problems with income. Some people are W-2 and you can simply figure it out. Others are self-employed. So let's say we have a plumber, and the plumber reports his income is $30,000 a year. Though he has a nice home, has a vacation home in Vermont, is driving Mercedes-Benz, has a jet ski and a boat. The court will look at the actual monthly expenses for this plumber to figure out what his true income is. And let's say to meet his annual expenses, it might be $90,000 a year, but he only reports 30 or 20. So the court will state, well, he's not telling us the truth, therefore we're going to impute income for him. Now, the bigger problem for someone who says that they're self-employed and this is my income, since the court is now imputing income, they can decide to make it a higher amount than the person's actual income. So let's back to our plumbers. Says he's making 20, 30. His annual expenses are 90. The court might impute income at $140,000. All of a sudden, he's now paying, if his income is really 90, he's now paying $50,000 income child support on that additional $50,000. So you just figure out 17% of the additional $50,000, it becomes very expensive. So it's important that everyone be truthful with the judge in Supreme Court or the support magistrate in family court as to your income. Okay, another component besides child support and custody is visitation. When does the non-custodial parent see the children? If all depends upon the ages and actual location of where the parents may be. If the parents sort of live near each other and the children are under kindergarten age, many times the parties will use a 2-2-5 schedule, which is Monday and Tuesday with mom, Wednesday and Thursday with dad, and then they'll alternate the weekends. With a schedule like that, one parent will get a solid 5 days with the child or the children. If the children in school, the courts many times like the children to be in one location at one time. That's when school was open. So when they have their books and can talk to their friends and know where they would be. A normal non-custodial visitation schedule when the children are age 5 or older would be alternating weekends, Friday through Sunday, twice a week for dinner, Tuesdays and Thursdays, alternating the 13 major holidays, alternating some religious holidays, alternating the school breaks, winter, spring, and April and Easter, and 2 to 4 weeks during the summer. Each party is unique as to what their schedule should be and how they can work it out. Some parents just refused to allow the other parent to spend any time with the child. I was in court 2 weeks ago. I have a mom very nervous about dad. He hasn't been in the picture for a few years. Came back now, wants to have visitation, and mom's awfully nervous. Finally, we had to have the court order the visitation, that the father would be spending the alternate weekends and would actually have 2 weeks during the summer to make up for all the time that was missed from March to April. So March to July. Okay, another issue in a divorce, maintenance. Fancy word for alimony. Jerry mentioned it before. It's money to continue the lifestyle that the parties had during the marriage. And I always tell parties that history dictates the future. If you've been spending a few $1,000s a month on expenses, and all of a sudden you decide to leave the house, and well, if the wife's going to continue to pay those, meet those expenses, you're going to have to pay them. If you leave the house, you're going to have to pay the mortgage, you're going to have to pay the utilities, you're going to have to pay everything. You just can't run away from your responsibilities. Now, the court has a formula to determine temporary maintenance. Temporary maintenance is, let me start. At the very beginning of a divorce, the parties show up, they have a conference with the court, the judge's law secretary. If they can settle the case, they try to. If they can't, one party will make an order to show cause for pendente lite relief, fancy Latin language for a financial band-aid during the marriage. During the divorce. A divorce can last anywhere from 3 months to 2 years, depending upon how difficult it is between the parties, or the court being closed, or the attorneys being difficult. So there's a temporary maintenance formula. The court uses a slightly complicated 3-step formula. Fortunately, there's an online calculator on the NewYorkCourts.gov website for both attorneys and judges use to determine temporary maintenance. The court once again uses a cap of this one of up to $192,000 of the payer's income to figure out what the maintenance should be, and the number is even lower if there's also a requirement to pay child support. And if the income is greater than 192, then the court can apply 15 different maintenance factors as to, my apologies, I keep hitting my computer, as to figure out how the maintenance should be. Then, if there is a actual trial, the court will then determine permanent maintenance. And there's a suggestion as to what the maintenance should be. For the 0 to 15 years, maintenance should be 15 to 30%, more than 15 up to 20 years, 30 to 40%, and more than 20 years, 35 to 50%. So the court has a lot of discretion to determine maintenance. Sometimes the courts will bring the parties in to try to force maintenance and resolve it. For example, let's say it's a 10-year marriage, which is a long-term marriage in New York State. The court could award non-durational maintenance, means maintenance for life. I don't see it, doesn't normally happen, but it could. So they'll bring in the husband who might be paying maintenance, and the court will state to him, if you don't settle on the maintenance now, I might award it for life. So I suggest you pay, let's say, 5-6 years of maintenance. A rule of thumb in maintenance is for, let's say, 1 year for every 3 years of marriage. So let's say if the parties were married 10 years, you're looking at about 3 1/3 years worth of marriage. So in this case, the judge might force the husband to pay 4 years worth of maintenance, maybe 5 to end the case. Then he'll drag the wife in and say, well, it's 10 years of marriage, but I have ultimate discretion. I might award just 2 years or 3 years. So maybe you should just settle on the 4 years. And so the court will force the maintenance to try to get the parties to settle. Judges have numerous cases on the calendar, maybe 400 to 500 matrimonial cases on the calendar. They don't have time to try each and every case. The way a calendar works in a courthouse is when the courts were open, we have 40 cases on the calendar each day. Court was supposed to start at 9:30. The judge might come around 10. They'll conference 20 of the cases from 10 to 12:30, and then the judge will start or continue the trial from 12:30 to 1, and then court's supposed to start at 2. Judge will come back at 3, and from 3 to 4:30, you'll get your other hour and a half for your trial. If you're dealing with custody, visitation, child support, maintenance, equitable distribution, your trial could last 2 weeks. And if you've got to come to court every single day to get an hour here, an hour and a half there, it's going to be very time consuming and also very expensive because your attorney is going to be there all day long, doesn't know when the judge is going to call the case. So the attorney's ready to go at 9 a.m., even though the judge might not start the trial till 12:30. Okay, our last component and criteria in the divorce is equitable distribution. Now, what is equitable distribution? It means splitting assets equitably, not equally. So if there's a toaster oven and a microwave, one takes the toaster oven, the other takes the microwave. They might have different values, but it's sort of equitably. Now, the court deals with equitable distribution of marital assets. So what is a marital asset? Well, a marital asset is marital asset is anything that's not separate property. Separate property refers to property that's owned by one spouse individually prior to the marriage. That could be also property that one spouse has received as a gift from a third party during the marriage, or even received as an inheritance. Separate property, even though, can become marital property. Marital property basically is from the date of marriage to the date of the commencement of the divorce action, any property acquired by either spouse, which is not separate property, is marital property, and that gets shared. Now let's just cover separate property, which actually becomes marital property through the process of either transmutation or even commingling. Okay, transmutation of real property occurs when one party owned the house prior to the marriage, and then during the marriage, that party decided to add the spouse onto the deed. Well, that would be possibly a donative intent to have that property owned by as a gift, and therefore the property could be owned by both parties, now a marital asset. Also, you could have commingling when one spouse uses marital funds to improve or maintain or contribute to separate property. For example, the house is owned by you prior to marriage, but if marital funds are used to improve the house, such as putting on a new deck, that could increase the value of the house. Therefore, that's marital appreciation on this separate property. Now, the court, in deciding equitable distribution, has 14 separate factors to help the court make this decision. To me, the most important one is the last one, which says any other factor which the court shall expressly find to be just and proper. So how do you protect yourself from the court deciding? Use a prenup, use a postnup, or have a separation agreement. Now, there are different ways to resolve a divorce. There's mediation, there's collaborative law, an out-of-court settlement or in-court settlement, or, of course, trial. Now, what are the different costs besides attorney's fees in a divorce action? I mentioned before the forensics for custody. Now let's get back to our plumber. Our plumber has his own business. How much is the business worth? Well, he's going to state it's worth very little. The court needs to do an evaluation to determine how much that business is worth. And that's a forensic business evaluation. That can cost $5,000 to $15,000 also. That could take 4 months. All the business records, tax returns, profit and loss statements, and everything else with the business all has to be given to the investigator, who then generates a report for the court to determine the marital value of that business. Now, let's say the business is worth, I'll take an absurd example of the case I had. A man was a single business person selling, he manufactured t-shirts in Mexico. And if he stopped, he was 65 years old. If he stopped business, there would be no value to the business because he would stop working. He was a one-man operation. Well, the forensic business person valued the business at $265,000. Now, even though it's a marital property and it's worth $265,000, the question is, will the court award the wife 50% of that business? Many years ago, the courts were awarding 50% or so. I tell clients now the court normally awards about 5 to 25% of the value of a business to the other spouse, because even though there's a marriage is an economic partnership, but if the court believes that the wife didn't contribute to the business, she wasn't there running it, wasn't making phone calls, wasn't sending out bills, whatever it may be, that she doesn't have that much of an interest in the business. Another hidden fee besides the forensics for the business and the forensics for custody and the attorneys is the attorney for the child. If custody is sought or there's problems or an offense petition is needed for temporary order of protection, the court can appoint an attorney for the child. The court, that normally costs $3,500 to $5,000 to start, and the price is either allocated 50-50 or pro rata based upon the different parties' salaries. And another fee is a house appraisal. The house is going to be one of the marital assets to be determined to be split up. We need to know how much the house is worth. You don't use Zoom. You don't use a realtor. You use an actual real estate appraiser that the court utilizes, and that's only about $500. So that's not too bad. So even if you get through your stipulation settlement and states that one party is supposed to pay amount of money and doesn't comply, or there's a court order after trial and the person doesn't comply for payment of maintenance, payment of child support, or selling the house, what happens? Well, now you have to spend more money on legal fees to bring a post-judgment of divorce order to show cause to compel compliance with the stipulation, compliance with the court order. Normally, this order to show cause is for contempt. Therefore, it must be personally served upon the ex-spouse. But if the contempt is proven, then the court can award attorney's fees. So motions, order to show causes, court appearance, legal time, everything else, it's very, very expensive. So parties can resolve their differences out of court with the help of two attorneys in a four-way meeting where the two attorneys and two parties get together in one attorney's office, sit there and discuss all these major issues, then hopefully that can be resolved. Okay. Now we've discussed the divorce. Let's discuss a subtopic dealing with the real estate or the marital residence and the divorce. What happens now during COVID-19 to do a closing in case the houses be sold? Parties are quite fearful of going out in public. I had one client that didn't even want to leave his home. We had to have the deed and all the transfer documents signed by him in advance. Had to resort to e-notarization to get the documents signed through Zoom. Then had to drop off the paperwork at the bank's attorney's office. Wait for them to tell me the closing was fine, and then to go back and pick up the checks. Biggest problem in the divorce, besides getting custody of the children, is what to do about that home. To many couples, the home is their greatest asset. They also have sentimental value with it. So what do the parties do? Do they sell the home, delay the sale until the youngest attends college, or one buys out the other? Let's just cover all these different issues. assuming that there's equity in the home. How do we figure out equity? It's the fair market value of the home minus any mortgage and any HELOC, which is a home equity line of credit. That gives you the equity. And if it's a marital home, then the equity could be up to 50%. Okay. Now, how the title to the house is held during the marriage is unimportant. If the house is bought after the marriage and it's only deeded in one name, the house still is marital property. Times a house could be in tenants by the entirety, tenants in common, joint tenants, could be in the name of a corporation, LLC, or a trust. But you analyze it, figure out if it's marital property, what you're entitled to. Now, even if the house is marital property, there could be some separate property component. For example, if Ms. Jones, prior to her marriage to Mr. Smith, had $300,000 in her bank account from money she earned in her job. If after marriage, the house is purchased solely in her name, and she can trace the $300,000 from her checking account to the purchase of the home, she gets a credit for that separate property. Now, since it's $300,000, she gets all $300,000. If the house is worth $600,000, she'll get a credit for $300,000. And we discussed before the marital appreciation, where the house is owned by one person, but the other spouse does improvement to it, puts a dormer on, makes the house go up in value from 200 to 300. That's an increase of 100. That other spouse might be entitled to 50% of that 100,000 increase. Now, if the parties decide to sell the home immediately, the benefits are getting rid of bad memories. The house has bad memories, such as the bedroom where your spouse had the affair, you'll be getting rid of that house. Also, satisfaction of the mortgage, the liens, and anything else. And then you'll share in the equity. You can even take advantage of capital gains, taxes there. If you're jointly selling the home, you sell it together, you can get up to a $500,000 credit on long-term capital gains. There's a number of ways to qualify for this exclusion. One spouse living there for 2 years of the last 5 years, both using as a principal residence. Neither spouse used the exclusion the prior 2 years. I suggest that you check out IRS publication 523, Selling Your Home. There's a section on addressing capital gains. The best way to do it is simply to ask your accountant, am I entitled to capital gains, and what is it, and please let me know. Now, issues with selling the home. Picking a realtor. Whose realtor do you use? Yours? Your wife's? What price do you initially pick at? Should you advertise it as a divorce sale? I wouldn't, because the potential buyers might think that you're selling it out of desperation, thus looking for a lower price. Sometimes we have in our separation agreements that if they'll use the average of 2 realtors to figure out what the initial selling price should be, and then put in a schedule there that if the house isn't sold every 60 days, that price will drop by 5%. Now, what happens if one person doesn't want to sell the house? For example, the wife's in the house, and the agreement, she agreed to sell the house when the child turns 18. Child turns 18, well, she doesn't want to move out. You'll have to go to court to force and compel her to sell the house. I've seen cases where the wife, when potential purchasers have come in the house, she has put dog feces all over the home. She's told the neighbor about the plumbing issues and all the problems with the neighbors. No purchaser is ever going to want to buy that house. Also, or you get the problem where you finally found a purchaser and one party won't sign the contract of sale, won't sign the deed at closing. You'll need court intervention one more time to have one party appointed receiver to sign on the other's behalf. I have a case pending, and I'm waiting for the decision today, where I have the wife trying to sell the home, the husband's in jail, and the mortgage is only in her name, though the deed's in both names, and they agreed upon a price, and then they agreed upon how much money she gets from the closing, and then the husband reneged and wanted her to get even less and less money, and finally said, well, I'm not going to sign the deed, I'm not going to close, I don't care, I'm in jail for the next 3 years, and hell to you. So we had to go to Supreme Court and ask a judge to appoint her as the receiver. If she is the receiver, then she has the right to sign the contract, the deed, and everything else on behalf of the husband, so the house can eventually be sold. Benefits of a buyout. If there are kids and they're young, they can stay in the same school district and be with their friends. The house can be sold when the youngest heads off. Also, if the market's no good right now, can wait till the market gets better. Now, concerns, once again, in the buyout, determine the value of the home. I always suggest to the person who's going to be staying in the home to have a house inspection. Just like if you're buying a house, you need to make sure the house is structurally sound and there are no issues such as plumbing, electrical, or termites. Also, you have to make sure that a dormer wasn't put on or an extra room wasn't put on to the house, which no one ever obtained a permit for. If there was no building permit for it, then there's no certificate of occupancy or certificate of completion, C of O or CSC for it. Those items will be needed, desperately needed when the house is sold. The house might not be sold if you don't have those CUCs and C of Os, so you'll need to do that. I also suggest ordering an attorney search title report to make sure that the other spouse hasn't caused any liens or judgments that you didn't know about. Someone can actually consent to a money judgment. So the husband's really in a bad mood, the wife's staying in the home. He could consent to a money judgment to someone for $15,000. That lien will appear on the house, and when the wife sells the house on a future date, she will have to take care of that problem. Now, with C of Os, I mentioned before, if you don't have the building permit, and let's say you put a back deck on, and the deck is too close to the neighbor's home, so not only do you need a building permit for the deck, you're going to need zoning variances because it's too close to the side yard setback or to the rear yard setback, and it's just problems. Okay, now if the wife stays in the house, the husband has these issues. He's still on the mortgage, and even though the wife's in there, he's still obligated to pay the mortgage while the wife's still living there. And if there's non-payment, the bank can come after him, even though he's not even living there. Also, he might still be liable for carrying charges for utilities and other items. Winning is everything to some people, but owning the house, you can't take a brick to the bank to pay the mortgage. If you don't have enough money from your income, payment of maintenance, payment of child support, you can't afford the house, maybe it's time to get rid of it. Now, sometimes you want to keep the house and get off the mortgage. Then the other party would have to refinance or obtain a HELOC. Sometimes you don't have the income, and the bank might not do it. Okay. Now, also, the utilities I mentioned before and carrying charges, also the husband might still be liable for the real estate taxes, school, general, and village taxes. So those are all issues to be concerned with. And as I mentioned before, if you got to go to court, the person won't leave the house, and you have to force the sale. It could take up to 18 months in court to get that person actually out of the house and sold. It's a long, arduous process. Once again, try to settle. Okay, let me look at my timing. It is 11:50. Okay, let me briefly touch on landlord-tenant law. Evictions in New York State have been stayed since March because of COVID-19. Evictions were supposed to commence on August 5th, 2 days ago, but Governor Cuomo just extended that to September 4th. So there will be no evictions commencing until at least September 4th. Right now, the landlord-tenant courts aren't even open for normal cases. For example, in New York City, housing courts only open for emergency cases permitted by the courts if you're locked out of your home without a court order or you need emergency repairs. The court is accepting new eviction filings, but not for non-payment, for any other reason. So these poor landlords just sitting there, not collecting rent, can't get rid of the tenant. And once the courts, if they do reopen, it will be, with all the people coming in, it'd be like a tsunami, trying to get through the courts, trying to get your non-payment judgment, trying to get your eviction papers, trying to get the eviction warrant, eviction picked up by the marshal, the sheriff, and for the eviction to actually occur. Okay, let's cover some elder law and estate planning, issues of guardianship, healthcare proxies, and other fun stuff. What is estate planning? Well, basically, if you think you're going to become incapacitated in the future, you want to set forth a plan who will handle your affairs. And if you die, you want to have a will or as to what will happen to your assets. And if you have minor children, who will care for them and their property. Let's first cover incapacity. Many people, even they're feeling young and healthy, come to the office, they like to get a will done, they're concerned about what will happen to their assets and what will happen to their, or if they have young children, what will happen to them if they should pass away. We can set forth who their loved ones are in the will, what will happen to their assets, who will receive them, who will be appointed an executor. That is a person who is responsible to marshal up all the assets, a fiduciary of the estate, collect those assets, and make payments of those assets to the designated beneficiaries. Also, they would actually have to wait. I tell my executors to always wait 7 months after letters testamentary have been issued, because if they make payments and creditors come in who've made valid claims and they paid the money out before the claims had been taken care of, that the fiduciary will be personally responsible to pay those claims. For example, someone dies 3 months later, letters testamentary issued after the will is probated in surrogate's court, and all of a sudden the landscape becomes 6 months later and states, I didn't get paid for last 3 years worth of work for $4,000. Well, if it's a valid claim and the executor has to make sure it's a valid claim, the claim would then have to be paid before any of the monies are paid out to the beneficiaries, or actually the people named in the will, or else once again that executor will be responsible. So if your will, you can only name your loved ones and only name what they're going to receive. Now, if you're married and you don't leave anything to your spouse, we're back to divorce law again. Person dies, they left nothing to their wife, left everything to the children. Well, the wife has something called a right of election. She can seek 1/3 of her husband's estate to be paid to her. So even though you on the will you stated you've cut her out, you actually have it. Now, can you cut out your children, your loved ones? Absolutely. They might have a birthright entitlement to your money, but they don't have a legal right entitlement to it. Okay. Now, that covers a will, and a will is normally in writing. It's witnessed by 2 people. I do it in my office. You have to declare it as your last will and testament, and you're requesting the 2 people to be your witnesses. The witnesses then need to question the testator who's making the will to make sure they have testamentary capacity, means they're lucid, and now also that the will is properly done. If the will is not properly done, or there's no testamentary capacity, that will can be stricken. And if the person dies without a will, then New York state law determines how that estate will be distributed. If there's a spouse, $50,000, and 1/2 of the estate goes to the spouse and the other half goes to the children. We have a case right now where the woman died, was divorced, her children are young, under age 18, and didn't have a will. She died, the house, because the house is solely in her name, we need to do an administration proceeding, which you go to court, submit a petition just like you do for probate, ask the court for letters of administration, and the administrator, just like an executor, is responsible for collecting the assets and distributing them. In this case, the money goes to the 2 children, who were, I think, ages 10 and 12. And if the house gets sold, the equity in the house is $300,000. So, but the children can't take the money. They need a guardian. So you actually have to apply in surrogate's court, not only for administration, but for guardianship in order to take care of the property of these children. Now, in a will, can you put down when ages that your children should receive money? Yes. Or you can even do trusts. You can say, instead of my children receive money at age 21, maybe I'll give half at 25 and the other half at 30 because I don't think they're responsible enough. So you can do that and determine when they will actually receive their money. Okay, now what is, besides coming in for a will, many people also get a power of attorney. Now, what is a power of attorney? It is a form which allows, if properly signed, executed, 12-point font and everything else that's required under the statute, allows the principal's agent to make decisions on behalf of the principal. For example, if you sign a power of attorney and give unfettered choice for the agent to do whatever the agent wants, that agent then can, if with that power of attorney, utilize it and do things with it. For example, you give the power of attorney to someone, that agent could buy a car in your name, could buy a house in your name. That power of attorney is effective until revoked. Sometimes people get a power of attorney because they figure they might be Alzheimer's or something else, or they might get sick, they might be in a coma, and they want someone else to make decisions on their behalf regarding their financial end. So the power of attorney would handle that. Along with the power of attorney, you can actually get a statutory gift writer, which is a separate document which actually allows the agent to make self-gifting. So the agent can actually give money to himself or herself. So it's very important to pick your agent, also as to what powers you want to give them. Along with the power of attorney, many people come in for a healthcare proxy and a living will. Those two documents work hand in hand. If you are in the hospital on a respirator and you're not coming back, you can allow this person to make life-ending decisions for you, such as pulling the plug on the machine. So those are also very important documents, the healthcare proxy and the living will. Now, lastly, if someone is incapacitated, they don't have a power of attorney, what can you do for them? I have a case right now where a construction worker was installing surveillance cameras, fell off an 8-foot ladder, landed on his head, traumatic brain injury. He's been in the hospital for 3 or 4 months. He's had all sorts of different surgeries. He's barely coherent, and he can't do anything for himself. Poor 35-year-old guy. A law firm wants to sue on his behalf, the employer, but they can't do it unless there's a guardian appointed for this gentleman. So I applied for a guardianship to the Supreme Court for this person. And the court, after hearing the case, actually had a Skype hearing. We didn't have to present any evidence. We had to submit all our paperwork online. The court conducted the hearing with my client, who's his brother, who wanted to become the guardian for him. We had him, we had the Spanish interpreter, we had the court reporter, we had the judge's law secretary, myself, and the judge all on Skype, and we got it done. And the court will be cutting an order for me that the brother will now become the guardian of the person who fell off the ladder in order that they can sue. Also, this guardian actually has life-ending decision rights and a bunch of other matters. It can make a decision for him on his behalf because we requested it in court.